Okay, welcome to seminar. We're going to go through a few announcements and then I'll do some introductions. By way of announcement, tomorrow at 3 to 4 o'clock, we have MHTN Architects coming for an info session in this room from 3 o'clock to 4 o'clock. So that's a great opportunity. Make sure and not miss that. Next week for seminar, we have the NAHB teams as well as the ASE teams are going to be presenting just brief snippets on their presentations that they performed at the competitions in both the ASE and the NAHB. And if you didn't know that, now you know it, and I'll reach out to you with the details. So be prepared. For today we have Mike McGuire, and he'll be presenting here. He's also accompanied by his wife, Sharon McGuire. And let me introduce them. First off, they're my wife's aunt and uncle. And so we see these guys often. They're great, and I'm really appreciative that they were willing to come up here to Rexburg to present. So Mike McGuire is a retired trial lawyer from California who practiced law for the past 32 years. He has served as the assistant legal affairs secretary to the governor of California, as an administrative law judge appointed by the governor, as well as a settlement judge appointed by the Superior Court of California. He has published opinions in the Ninth Circuit Court of Appeals in the United States Eastern District Court of California, dealing with federal civil rights and freedom of speech issues. He has practiced construction law for the past 20 years, having defended general contractors, developers, subcontractors, and product manufacturers in construction defect lawsuits. He has specialized in complex litigation involving more than 35 parties and has conducted destructive investigation of more than 400 homes throughout the western United States. Mike and his wife recently returned from serving a mission for the LDS Church at the Caribbean area offices in Santo Domingo, Dominican Republic, where he served as the associate area legal counsel in charge of litigation, construction issues, and acquisitions, while Sister McGuire served as the executive secretary to the area presidency for the governmental affairs and handled visas and driver's license issues for missionaries in 8 missions. In addition, Sharon was the executive director for the California Landscape Contractors Association prior to serving their mission. Mike is, on a personal level, Mike is also an avid hunter and would appreciate any tips on good elk hunting spots in Utah or Idaho. So come talk to him. Welcome, Mike.
Thank you for coming today. I hope I can make this worthwhile for all of you. Whenever a lawyer talks to you, the first thing you have to do is determine what his or her biases are. And I want to disclose to you right now what my bias is and why I'm here. I first met Adam when he married my wife's niece. She was this drop-dead gorgeous, beautiful girl. And I thought, man, what a lucky guy. And he was a Jamoke from Anchorage, Alaska, or that area. And I thought, how in the heck did he ever pick her off? And then I found out later at the next family reunion, he shows up with this 5.5-foot long potato gun. Now this is not just any potato gun. This thing had a velocity of probably over 1,000 feet per second. And it had an 8 or 10-inch expansion chamber into which we experimented with WD-40 and hairspray, and I think there was some starting fluid as well. We resolved that the hairspray worked best, but this thing shot a potato across the road and through the wall of a barn that was collapsing. And ever since that date, I have just worshipped at the feet of Brother Everett. So if you're...
tell me about survivability.
So, before you leave here, be sure and get the design plans for that potato gun. This is a man stopper of a gun. Today we're going to talk about construction litigation and the role that you as construction professionals are going to play in it. I'm not sure what all of your motivations are for being here. Some of you like to build with hammer and nails and wood. Some of you may be looking for a job where you don't have to talk to people. Some of you may want a job that doesn't require a lot of writing. I think you'll find as you stay in the construction trades, in the industry, that all of those things are going to become important to you. At the end of today's presentation, I want to share with you some ideas that I have seen over the last 20 years that will help you avoid litigation, and if you are sucked into it, and I hope you aren't, that may help you win. The odds are really good that you're going to be involved in a CD case at some time in your professional career as a construction professional. Whether you're involved as a witness or as a defendant, the odds are real good that you're going to be real concerned about what's happening, because your name may appear on the face sheet of a complaint. Now, there's two documents that hopefully all of you have received prior to today. One is a complaint in the Superior Court in California. It's for a construction case, and it's in Lassen County, California. The other is a notice of deposition for a homeowner, project owner. And I wanted you to see these documents because these are really the motive documents in a CD case. And you're going to be able to get a sense, I think, today of how specious a lot of these construction cases are. Now, I'm a defense guy, so I'm going to be talking from a defense perspective. I'm the guy that you call when you get sued, and I drive onto your job site or I go to your office or whatever, and I meet with you and I become your best friend, because prior to trial, you and I get to know each other really, really well. The longest trial I've ever been in a construction case was 12 continuous weeks in San Jose. We were representing a product manufacturer, a hardboard siding manufacturer from Oregon, and he was being sued for an 877 unit apartment complex, and they were asking a minimum of $77 million. We had 5 insurance carriers defending our client, 12 weeks of trial just to determine whether or not the developer, owner of the project, knew that the siding had been put on incorrectly. Now, as construction professionals, you're going to deal with engineered products. Does anybody know what an engineered product is? Yes, sir. What is it?
Something they manufactured, like the round boards. They're just pieces of 2x4 stuck together.
They are, and that's it. He said glulam boards, glulam beams, anything that is manufactured based upon engineering statistics or engineering review, and it is required to be installed in a certain fashion before a warranty or a right to warranty is triggered. Whenever you use engineered products, whether it's a windows are engineered products, whether it's hardy plank, cementitious siding, these products come with installation instructions, and they must be installed in the fashion that the manufacturer requires, or there is no warranty that follows that product. Well, on this particular project, my client's siding looked real bad. It was wavy, and it had ridges, and they had leaks into the buildings. We were able to find a guy that was driving a truck, and he delivered the siding to the project, and he had taken photos of the project in the initial stages. This was a 3-year project, building 877 units in San Jose. And we were able to take those photos and blow them up and show how the general contractor had stored our client's product in the mud, uncovered. How he had applied the siding with nail guns and had failed to caulk over all the holes. He had failed to hit the underlying studs. He had a lot of what they call shiners on these boards, and the boards were sucking in moisture and they were failing. At the end of that trial, we got a verdict for our client and saved his insurance carriers $77 million. But to get to that point, we were burning through $150,000 to $175,000 a month for just legal fees. Now that's a lot of money. And that's why insurance carriers do not want to stand behind you as the contractor if and when the big balloon goes up. So you need to be prepared for what you're going to find. There is a proliferation of CD cases in the western U.S., except for Idaho and Utah. And I don't know if that's because of the lack of licensing requirements, but in California, Nevada, Arizona, Washington, Oregon, and New Mexico, and now starting in Texas, there are so many CD cases that the courts are beleaguered by them. In California alone, each of the major jurisdictions, and there's 58 counties, of which 32 are major jurisdictions, they have created their own construction defect departments which handle these CD cases. And you go in there from the day that the case is filed, and you are given a trial date, and you are given a window of time to try your case. Now, how many of you have sat as a juror in a civil case, not a criminal case, but in a civil case? Anybody? Anybody? Okay. Juries don't make decisions based on the merits of the claim. I have found juries make decisions based upon how far the juror had to park from the courthouse, whether or not the cream he put in his coffee that morning was sour, whether or not he had an argument with his significant other. After the first day, you can look at the jurors and they're no longer taking notes, and they're just spaced out. And you, as the defense lawyer, start to panic because your client's life is at risk. You, as the general contractor, as the project supervisor, your livelihood is at risk. And it's in the hands of someone who is angry, doesn't want to be there, and knows that he's going to have to sit there for another 6 weeks at least away from his job, listening to a sob story about why this window leaked. So that's the background of where we're going. The plaintiff's bar, the people that actually file the lawsuits, are driven by money. Do you remember the old Jerry Maguire movie where he was always yelling, "Show me the money"? That's really what CD cases are about. In every one of the settlements I've seen, where there are a large number of homes, and I've handled claims of as many as 300 homes in one subdivision at Del Webb, none of the plaintiffs took the money and made repairs. None of them. They took the money and they bought a Mastercraft boat, or they bought a big Dodge 3/4-ton diesel. They took it and they played with it. They didn't make changes to their homes or make repairs. And yet they were ready to go into court and tell the judge and the jury that my life as I know it has come to an end. My dog died, my wife has left me, my life's in the dumper. Yet they wouldn't make repairs when it was all said and done. It's because money is driving this. Insurance has two duties in all the states. One is to pay for a defense for you as the policyholder or your employer, the general contractor, let's say, and the other is to pay judgments. The duty to pay for the defense is absolute, and it's triggered by the least form of notice, by the most minimal amount of notice. The duty, on the other hand, to pay judgments is open to debate. And that's where the insurance carriers want out. That's where they're going to come to you and start scaring you and telling you that they may want to jump ship on this particular claim, and you do not want to be left uncovered going into a trial. We now have, since 2000, the duty on the part of the plaintiff's lawyer to establish consequential damages. Because remember, an insurance policy does not cover your work. If you're the window subcontractor and you negligently install a window, the window doesn't work, insurance won't pay for the replacement of that window. But if that window leaks, because instead of using mastic, you went ahead and hammered 12 penny nails through the nailing fins, in through the paper, and the window leaked, and the assembly leaked, and the walls leaked, then they will cover that because that's consequential damage. I'm going to have some pictures in a few minutes of an $8 million home with consequential damage that never should have happened. In all the states in the West, we in the defense bar, and you as contractors face the distinction between patent and latent defects. In most states, when you buy a home, for those of you that have bought a home, this will be familiar to you. You go and you walk through your new home and it smells like fresh paint, and the carpets are all springy, and the toilets are clean, and I mean, it's just a beautiful place to be. and you love that new home smell, and they give you a book. The developer, the general contractor, gives you a 3-ring binder full of all of your warranties and all of your instructions about, well, this is how you turn the oven on, and what happens if it says F7 in the fault window and your microwave won't work. Included in that is a builder's warranty, and it usually lasts for 1 year. And in some states, by law, it lasts for 10 years. California is one of those states. And this says that for latent defects, those are defects that you can't see. For latent defects, the homeowner, the original homeowner, or the subsequent homeowner who buys during the first year of ownership by the original homeowner, they have 10 years in which to bring their lawsuit. I have a copy of a construction defect complaint for you today that deals with an Indian casino. They brought suit 8 years after the completion of construction on their project. And they're claiming that for those 8 years, they didn't see any problem at all. But I'm going to go over some of the defect claims with you, and they had to have been blind. They had to have been blind because they talk about water running into the rooms. Now, for those of you that are married, particularly you young men, you will probably already know that your wife has certain standards that you must adhere to. Standards in dress and decorum and how the house is going to look. I remember really well, I had a roof case in Placer County, California, in a very, very expensive home. It was about $750,000. And I was taking the deposition of the husband. And I said, when did you first notice that the roof leaked? And he sat up and very pompously said, well, I was asleep with my wife just laying there, and suddenly I felt water dripping on my forehead. And I said, no kidding. And I said, and how long did that water drip on you? Oh, every night. Whenever it would rain, the water would drip on my forehead. And so I said, well, what did your wife say to you? Oh, well, she didn't say anything. She was always asleep. And so then I took the deposition of the wife. And I said, now, when we took your husband's deposition, he said that in the middle of the night, he was awakened by water dripping on his forehead. And she said, oh, it was more than that. It was all over the bed. I couldn't sleep. The pillows were wet. I kept yelling at him, get up and fix that leak. You got to do something. And I said, well, when did you find out about this? And she said, oh, gosh, it was in the first year that we owned the home. And I said, well, why did you wait 10 years to sue my client, the roofer? And she said, oh, I don't know. You got to ask my lawyer that. And so we immediately impeached the husband, who knew about the defect in the first year of ownership. That was a patent defect. It was open, obvious, and notorious. The defects that you're going to find that will bring you into court are latent. You cannot see them. It's in the wall systems. It's in the floors. It's in the roof jacks. It's in the roof ventilation systems. It's in the way the gutters are affixed to the roof. And when you add snow to that and freezing and thawing conditions, it's exacerbated. It's made even much worse. The purpose of the complaint that we're going to look at is to put the defendant or defendants on notice of what the claims are. In reality, again, follow the money. The purpose of the complaint is to trigger insurance coverage. I once talked to a good contractor, really, really successful. And I said, so how do you feel about filing bankruptcy? I said, you know, you've got all this wealth, all these claims. And he said, you know, if a contractor hasn't filed bankruptcy 3 times in 20 years, you're not out there working hard enough. And I was surprised as heck to hear him say that, because this guy was incredibly successful. He had a corporation yard with, I bet, 50, 60 pieces of heavy equipment. He had several hundred employees, and yet he had personally filed bankruptcy 3 times because of these CD lawsuits. The purpose of the lawsuit is to trigger insurance coverage. Now, please pick up your complaint. It'll say endorsed, filed in the upper right-hand corner in the Superior Court of the State of California, County of Lassen, Susanville Courthouse. How many of you folks have one of these? I know that there were some more down here. Brother Everett, everybody have them?
There's 15 of them scattered throughout the audience.
Okay. This is an Indian casino case, and I have to be careful how I say this because I don't want to be sued for defamation. So it is my opinion that a lot of the Indian casino construction cases are pretty much a scam to get the casino rebuilt after 8 years on someone else's dime. Interestingly enough, under California law, the Indians are a separate tribal nation, and they have separate construction standards that apply to them. The Uniform Building Codes, or the California Building Codes, which apply to contractors, do not apply once you step foot onto Indian land. So there's a separate section, a separate set of codes that apply and control the quality and the standard of care for the builders on the Indian casinos. So this particular Indian casino had been built, I don't know when. The lawsuit says that in 2007, they contracted with Wright Development Company, and Wright had an operation out of Nevada. He also had another operation out of Oregon, and it turns out he was never licensed under the state of California as a general contractor, but that isn't brought up until the end of the lawsuit in the complaint. So Wright Development went in and they remodeled this huge Indian casino and hotel. Now, if you could, turn to page 2, and on the left side of the page they have numbers 1 through 28. Those are line numbers. And look at lines 7 through 10, where it said WDC, which is Wright Construction, was the general contractor that supervised, built, constructed, graded, inspected, and developed all or part of the hotel improvements constituting 900 Skyline Drive, Susanville, California. Now listen to the words that they have chosen to use. There's nothing that the contractor is not being held liable for. Supervised, built, constructed, graded, inspected, and developed. See how broad that language is? That poor contractor, they are really coming after this guy. Now go ahead and turn the page to page 4 and look at paragraph 15 under general allegations. This is where the standards of construction and the warranty claims come in the complaint. This is where you do not want to see your name personally. It says, defendants Wright assured the plaintiff that all design and construction would be completed within 270 days of the commencement of work, and the construction would be performed pursuant to all applicable codes, manufacturer installation instructions, industry standards, and best construction practices. You're going to see later on in the complaint that they're talking about engineered products. And the allegations are that the contractor failed to install the engineered products in accordance with the manufacturer's application instructions. The products failed. There was damage that was caused to the casino. Now go ahead and turn to page 5. The first cause of action is negligence. Now, this is not meant to be a law school class for you, but as construction professionals, you need to understand how the law is going to impact your practice in the construction industry. No matter what you are, whether you're a design professional, whether you're a construction professional, whatever, the law is going to impact your practice and your standard of care. Paragraph 19, it says, plaintiff is informed and believed. Now, when they use information and belief upon which to allege a claim, it means, to me, the defense guy, they don't have a lot of evidence. If they just say, Wright Development went out and botched the construction and he did so negligently, then they have to be able to produce evidence of that. They don't have evidence at this point in the lawsuit of what's going on. Plaintiff is informed and believes and thereon alleges that defendants and each of them had a duty to plaintiff not to construct, grade, build, test, inspect, install, equip, maintain, modify, repair, manage, supervise, operate, and otherwise direct the construction of the project in an unreasonable and negligent manner. What else is there left? I mean, this plaintiff's lawyer has identified every possible job duty for that defendant. Yes, sir.
Just a question. The contractor builds it, but it doesn't inspect it inspect it, it wouldn't be his fault if it was built wrong. And just like go and say like, oh yeah, this was built wrong, we need to fix it before we can move on.
On Indian land, no. The building inspector for the county of Lassen, where this particular hotel and casino was built, has no authority to come onto their land and inspect and red tag or do anything. Now, by contract, many significant projects hire an outside third-party inspector to come in and inspect the project. But when you read the contract between the general contractor, the owner developer, and this third-party inspector, the third-party inspector's contract waives any liability. And he essentially becomes just a second set of eyes to ensure that the project is being constructed in accordance with the plans. That's a very good question, and yeah, in the best of all worlds, we would hope that would exist. Unfortunately, in the real world, it doesn't. So then in paragraph 21, it says, as a proximate result of the breach of duty of these defendants, the biggest claim that you can have against you is one for negligence. To prove negligence, the plaintiff, the owner, the developer, whatever, has to prove that there was a duty that existed on the part of you as the general contractor to construct the project in accordance with plans and codes and standards within the standard of the community. That you breached that duty, and that the breach of that duty caused damages to the plaintiff. Now, damages is where it all boils down. That's where the money all comes from. I would invite all of you to read the rest of this complaint and see how they have come after this general contractor. If you were to read that complaint, and remember, the jury doesn't get the complaint. The jury only gets the evidence that comes in from the witness stand that the judge authorizes. If you were to read the complaint and you were the insurance carrier for that general contractor, you would panic. I mean, nuclear bombs would be going off. Oh my good heck, this place is falling apart when you read about what happened. The basis for a tort or for a CD case throughout the western U.S. are 5 causes of action, essentially: a tort, a contract, warranty, strict liability, and individual statutes in individual states, such as the patent versus latent defect rule that I showed you in California. In Nevada, they have Section 40, which is really interesting. In Nevada, for 4 or more homes in a subdivision, there's got to be a minimum of 4 homes. If the owners of the home get together, they can go out and hire a plaintiff's attorney and claim that there are damages to their home caused by negligent construction. The general contractor then has 6 months, a 6-month window opens from the date that the letter is served, 6 months in which to come and inspect the homes, make a determination that, yeah, the claim is legit, or no, it's not legit, and I'm not going to make any changes. And then at the end of the 6 months, the homeowners get to sue the general contractor. Now, in any type of a construction lawsuit, the general contractor immediately turns around and he files what's called a cross complaint or a counterclaim against all the subs that set foot on the job. So you immediately have 35, 45, 55 parties in a lawsuit. That's a lot of folks, a lot of lawyers, a lot of hot air being consumed and generated, and it becomes a real mess. And then the object becomes, how do I throw enough money at this plaintiff to get him away? Now, the key in a Section 40 case in Nevada is that the plaintiff's attorney gets his fees paid whether or not the thing ever becomes a lawsuit. At the end of the 6 months, the developer still has to pay the plaintiff's lawyer for his costs of inspection or investigation and all of his attorney's fees. So the plaintiff's lawyer never loses. This is a great gig. You know, they say it's good work if you can get it. This is the way the law is going in many states, particularly California and Nevada, where they are so overtly and just over the top consumer protective. The definition of a tort, an act or omission. This is important. You can do something negligently or you can fail to do something, and the failure to do something in a good standard constitutes negligence. So they've got you coming and going. That gives rise to injury or harm to another and amounts to a civil wrong for which courts impose liability. You never want to get caught up in this. And like I said, I'm going to go ahead and share with you some ideas about how to avoid that. The contract, most of you know this, it's an agreement with specific terms between two parties. You have a contract with BYU-Idaho. You signed it. It's called the Honor Code. If you live up according to the Honor Code terms and you pass all your classes, BYU will hand you a certificate, a diploma. And if you breach that Honor Code, BYU has the right to throw you out. The same is true of a general contractor, a developer, and an owner. If the general contractor breaches the contract by not providing services or installations in accordance with standard industry customs and in accordance with plans, then he can be sued. Warranty. A breach of warranty action is similar to a breach of contract action. And I went ahead and I pulled this from the state of Washington, the Washington Bar Association. This is a good example of the language of a contractor's warranty that many or most of you will sign when you start signing contracts for your boss or if you go out on your own. It says the contractor warrants that the work shall be in accordance with the contract documents and free from material structural defects and shall retain and repair any work not in accordance with the contract documents for a period of 1 year from substantial completion of the work or the warranty period. Now, that warranty is handed off to the subs who have the same language in their contracts with the general contractor, so that everybody who sets foot on the job, whether you're a hod carrier, climbing up a ladder with all your stuff for the roof, or whatever you are, you have given a warranty to the developer and to the owner that you're going to do everything in accordance with oil. So there's no way to escape the warranty. Negligence. It arises out of a breach of duty of care which results in damages. Negligence is usually established by expert testimony. Now, some of you may want to become experts. Please don't do it until you've had at least 8 to 10 years of hands-on experience. There's nothing that defense lawyers like me like better than to get a new shiny young expert up on the stand or a plaintiff and just go into the guy's background. And it turns out the only thing that he ever built with hammer and nails was a doghouse. And here he's giving opinions about elastomeric paint coatings and vapor moisture transfer and all this baloney that he doesn't even begin to understand, and he has no basis in experience for that. Remember, to testify as an expert in court, in almost every court in the land, you have to have skill, training, knowledge, and expertise. And that can be proven on what's called voir dire, where the attorney for the other side gets to ask you and go into detail about your experience. I once put on George Songus, who is an eminently nationally famous wood expert. And the issue was, in our siding product, how much time would have to elapse before a 1/4-inch hole left by an 8-penny nail would allow moisture to move through that board. The plaintiffs had an expert who was saying that it happens within the first 1 hour to 24 hours. My guy had actually done research into this, and he had written about 200 articles on vapor moisture transfer. And the plaintiff's attorney got into this on the witness stand with George, and George is he's in his 70s now, but he's a phenomenal skier. And I take my hat off to him. I don't know what he's eating, but whatever it is, I'd like some. And he has this big gray mustache, and he's an emeritus professor from Portland State. And so the plaintiff's lawyer asks him, well, you know, isn't it true that you really haven't done any research into vapor moisture transfer through 1/4-inch nail holes? And George stands up in the witness box and he says, now, Paul, because he knew this guy, he says, you know that's not true. And he walks over to the blackboard and he starts doing all this math on the blackboard. And the judge and the jury is just watching this, and this goes on for like 15 minutes. And the plaintiff's lawyer is sweating bullets because George Songus is establishing his bona fides as an expert. He's the kind of guy that you will want if you're ever hailed into trial as a defendant in a construction case, because that is expert testimony, and that's what the jury will listen to. In fact, they are instructed by the judge that the testimony of the expert is to be given greater credibility than the testimony of a non-expert when it comes to causation. What caused the damage? This is California Civil Code 1714. This is the general negligence statute. It's applied to everything. If you run over somebody in a crosswalk, that's the negligence statute. If you open your door at Costco and you hit somebody, or you knock a shopping cart and it goes down the road and hits somebody's car and causes damage, that's the statute against which your conduct is going to be evaluated. Every state has a general negligence statute. In 2000, the California Supreme Court issued what's called the Oz decision. Now it's pronounced Oz. It has nothing to do with the donkey, okay? But Oz says that to find a contractor guilty of negligence, you have to show that there's consequential damages. Otherwise, you can't recover if it's just bodily injury or damage to the property. Now, I've got some good examples of consequential damages. And just so that you know, this Oz decision has been cited as controlling authority by many courts in the United States. And it's now pretty much the majority opinions. You'll need consequential damages. This is a home in Los Lagos, which is out by Folsom Lake in a place called Granite Bay in Central California. They are estate homes. This one was $8 million. It's got all these just gorgeous decks. I mean, you can see all these decks all around it. The place is huge. It was like 25, 30 acres of land. And, you know, the guy had slave quarters and the whole thing. I mean, it was just a gorgeous home. We were defending the window guy. Now, the window guy's defense is always, well, it's the stucco guy. The stucco guy came along and he was putting his lath and stuff on it, and he drove nails through my window frames, and therefore the windows leaked. It's not my fault. Okay, so everybody blames and points the finger at everybody else. This is the back side of the home. Look at all these beautiful decks and overhangs. I mean, this is just a gorgeous, gorgeous home. This is an ASTM standard water spray test that we were doing on the top of the deck. This is a hose in which we measured the volume of water and the pressure. ASTM publishes all these standardized tests, and you have to do your testing in accordance with ASTM. Otherwise, it's just stuff that you make up, you know, from whole cloth, and it doesn't merit expert testimony. So we sprayed this down on the deck. We did this for 1 hour. We opened up a portion of the bottom of that pillar after the hour. And this is what the inside of the pillar looked like. You can see all of the damage that's been done over time from water entering those pillars. But remember, my guy's the window guy. And here's where the ceiling fell through. Now the plaintiff testified, yeah, I knew there was a problem when the ceiling caved in. This guy's a rocket scientist. So he goes out and he gets the plaintiff's attorney. The plaintiff's attorney drives out to this $8 million home in Los Lagos, and he says, yeah, you've got a problem there. So we bring in this guy, and these are his people here, and he's examining the wall. Now you can see what has happened here from water leaking over time. Oh, for your own information, this is 4 years after completion of construction. So the water has been leaking through that assembly ever since day one. And now I know that in California we haven't had a whole lot of rain the last couple of years, but we always get some rain every year. And just this little bit of water caused this. Now, I don't know if you can see the amount of damage to that wood. This is consequential damage. The window didn't fail, but the water coming in through the bad work above that caused damage to adjacent structures. Insurance coverage is triggered. And it's triggered for everybody that worked on that assembly. It's triggered for the interior drywall guy that did the drywall. It's triggered for the plumber. It's triggered for the framer. It's triggered for the guy who came in and did the flooring. So now suddenly the plaintiff's lawyer has got this huge pool of money with everybody pointing fingers at everybody else. No, it wasn't my guy, it was your guy, because he did this. You can see how this is starting to feed on each other. and how the money is just starting to pour into this plaintiff's lawyer. Here's what we did at the edge of the deck where we pulled it up, and you can see that there was this metal flashing that was put in. Well, the flashing never adhered properly. This, by the way, was not bent up when we removed the covering from it. This is the way it was installed, and they poured a liquid applied membrane over that deck, and they sealed that in with that up at a 20-degree angle. And so when the water came in from above, it came right through there and went down into the interior construction. Now this is a bad picture, but this is also at the corner of the deck, and you can see where the flashing itself has been damaged when it was applied. Now, if you are the contractor, or this is your first job, my experience has been that most young people who graduate from college, you'll get hired by a big general contractor, and he'll say, Adam, you're going to be the window contractor, and I want you to install these windows in accordance with the Milgard window application instructions. Now you say, hey, that's great, I'll do it. And so you come to work on the first day, and they give you your hard hat, and you've got your Ford truck, and you're ready to go out there, and life is great, just great. And then you come to work, and they tell you, now here is the critical path, and you're already 16 days behind, and oh, by the way, here's your budget, and you're over budget by $15,000. You have until Friday to correct that. So you spend your first week furiously going over the critical path, trying to find out how the heck can I accelerate this construction, build this properly, and at the same time recoup the 15 grand that I've got, that I have lost already. I've got to meet my budget because this is my first job. So the odds are you get out on the job site maybe a total of 20 minutes in the first week, and you don't see this. Now what if you did see this? Just before they apply the liquid membrane, what if you see that the flashing is bad? You get the sub out there and you say, tear this out. This is not put in according to detail 8/4A. Here are the plans, tear it out. He works for you, he has to tear it out. And you can make him tear it out as many times as you want. But unfortunately, you didn't see this because you were studying critical path and you were trying to recoup 15 grand, and it was your first week on the job. Now, I know that there are quite a few professors here who have served in the real world, and I think that you would probably commiserate with me that that's in fact what happens. That's the way the projects actually happen, particularly if you're building more than 35 homes or more than 1 or 2 large office buildings. Here's the outside of the deck by the doors. This was really bad. We took everything off here. We water tested the whole thing. Water started pouring in down through that piece of plastic that you saw in the ceiling below, and so much water came through in about 6 or 7 minutes that the plastic collapsed. Water went all over the floor, and of course the plaintiff's lawyers, they're videotaping everything. Just videotaping the heck out of it. Here's an example of consequential damage. You can see what's happened here because the liquid applied membrane never was applied up the side of the wall over that metal flashing like it's supposed to be. The plans called for it to go 8 inches up the wall. It didn't. It ended right at that turn. And you know, the deck appliers lawyer says, you know, my guy had a bunch of jobs to go to, and he remembers we were out there and we were mopping the stuff on, and we were trying to cover as many decks as we could, and we had another home over here, and you know, I just can't leave a crew there as long as you expect me to do that. Now, where was the general contractor's site superintendent? Why didn't he go and see that? Well, he was probably in the trailer dealing with his critical path problems. Now, this is in Mount Tamalpais, in the Bay Area, on the side of a mountain. Beautiful, beautiful, expensive places. This is a 4-unit apartment. You can see where the water is coming out of these scuppers. That's from the water testing that we're doing above that. And the complaint here was that water was coming down 2 floors, from the 4th floor to the 3rd floor. And this is what it looked like on the inside. Obviously, there's water infiltration that is appearing. This is a patent defect. You can see it with your eyes. It's not something going on behind the scenes that you can't see. That immediately triggers the statute of limitations that plaintiff has to sue right away. This is what a water test spray rig looks like. Again, we've got our valves there, we've got our pressure, we've got the distance that we have to have the spray nozzles from. Everything is done according to the ASTM guidebook. We're not out there just pulling stuff out of the air. This is what it looked like under the window on the inside of the house. This is consequential damage that we found from water coming down in here. We found that the window installer, this wasn't my guy at this particular time, the window installer hadn't applied his bead of mastic. He just slammed the nailing pins down and he went along with the nail gun and he put the windows in, because there were a lot of windows in this house and he didn't have the time to do that. So there was no mastic whatsoever, there was no sealing. Yes?
So in this situation, what happens if the guy sawing the trim notices that there's no mastic or caulk or anything around the window, and he goes ahead and throws the trim in?
Excellent question. When you as a subcontractor step foot onto a job site, if you start any type of your work, any aspect of your work, you have assumed that job and everything that went before you. You, according to the law, you assume all the problems in that assembly. That's why you, as a general contractor or as a subcontractor, should always inspect the work that is done before you put your trowel down. You have to inspect. You have to know what the plans are and what everything dealing or touching your assembly is required to look like. And if there's a problem, you go to the general contractor and you write paper on it. Now, I'm going to talk about the importance of writing paper in just a minute. You need to document. In fact, you need to become really good friends with the project architect. The architect is probably your insurance policy. Architects are not slouches. I have come to trust architects. They're not mischievous people. But you need to become friends with that architect. And when you send an RFI forward, you need to call the architect and say, hey, I'm sending RFI or CO number 25 or whatever to you, and I've got some concerns about this detail. You know, how can we make this work? My roofer says that we can't make this work at the roof jacks. How can we do this? And you meet and you talk with the architect and you get a paper trail created so that you know that the architect knows, hey, this may be a problem, and he identifies it and you come up with a change. It is your protection, it's CYA, and in your business you can't afford not to do that. So, this poor guy is on the second floor, and we're on the third floor doing water testing. He comes running up there, hey, my place is flooding! My place is flooding. And here he is, sweeping water out of his unit. Now, these are horrifically expensive units. I think they were $800 or $900 grand a piece. And this guy has got water all over everything. So, someone had to pay for that. So the leaks were even worse than we thought. This is a fireplace. This is my expert who noticed an opening in the fireplace front. He's sticking his little screwdriver in there to show that. We later water tested the fireplace and we found water coming down into the ceiling of the unit just below that because the fireplaces were incorrectly installed. You can see that water test there. This is a large multi-unit apartment house. This is another window case. These are my guys on the inside and the outside of the window, and they're getting ready to do the destructive testing. They've pulled all the finished stuff off of that. There's been no determination yet made about the window integrity or about the way that the adjoining assemblies were put together. This is what it looks like from the outside. These are spray rigs, again, ASTM certified. We start the spray rigs, we time them, we have log books, we have photos. We do all of this according to Hoyle so that it's admissible in court. And this is what we found. The guy who installed the windows, again, didn't put any mastic in. He just went through and used a nail gun. And he nailed everything in. And he so brutalized these corners that the water leaked down here, causing damage all over that. That whole assembly has to be replaced. This particular apartment complex had a big loss of use claim because they couldn't rent out these apartments that were leaking. And they had one whole side that faced the ocean that was all leaking. And they, I mean, it was in the millions of dollars for loss of use. Somebody has to pay for that. Here's another example. On the exterior, below, just below the edge of the window, there was this penetration here, and you can see some of the damage left over. One of the things that you're going to be told when you go to work, well, look, we don't really worry about the contract because we can go to arbitration. We have an arbitration clause. Or we have to mediate with the homeowner or the complex owner first. Don't be deceived by that. The difference between mediation and arbitration is really simple. In arbitration, you come out with a finding of fault and liability, and it can be enforced in court. In mediation, it's nothing more than getting the parties together and finding out how much the defendants will pay the plaintiff and whether or not the plaintiff will take it, and you shake hands and you walk away and the lawsuit is dismissed. That is tough to do because there's no finding of fault. And if you've spent your career or your reputation is on the line, you don't want to go to mediation because it's not an I'm okay, you're okay kind of thing. Your reputation as a good window guy, as a good framer, as a good builder is at stake, and you don't want to have it mediated away by an insurance carrier, but at the same time you don't want to pay. Now, how to avoid this? This is probably the most important thing of what I'm going to share with you today. If I had to do it over again, I would do this. Take photos. Take lots and lots of photos. Date your photos. Archive your photos and know where they are. How many times have I come to a general contractor and I said, hey, look, I'm your defense guy, and here's your depot notice. It's 18 pages long. Look at all these documents they want you to produce. And I said, where are your documents stored? Well, they're over in a warehouse. And I go over there, and it says Lower Lake job. And there's 45 boxes of documents. I have no idea what's in box 8 or box 9. Start archiving your photos immediately. On your very first job, if you're the window supervisor, take photos every day. And what's that going to show at the end? If you get called to trial, you can say, my windows were put in properly. And here's photos I took on day 1, day 3, and day 6. I've got 6 inches of flashing coming off the windows. I've got mastic in that nailing pin. There are no holes coming through this stucco. This is a perfect job. The pictures don't lie. They protect you. However, your employer may not want you out there taking photos. You're going to have to explain to him, this is the world we live in, and photos are going to save us. Secondly, memorialize your construction meeting with the subs. Attend those meetings. The last thing you're going to want to do is go to meetings where your site superintendent is meeting with all the subcontractors and saying, oh, hey, we're 3 days late on the stucco, or when are the windows going to be delivered, and we're having trouble with the water on the 3rd floor. Go to those meetings. If your site superintendent is criticizing the work of one of the subs, you memorialize it. And you're going to say, Jose Luna criticized the work of Joe Blow stucco guy today for the following, and put a date on it, and you keep those documents. You keep copies of them and you turn them in so that when you leave that job, you have your photos and copies of all your documents with you, and you and your wife go somewhere and bury that in the ground and keep it. It's so easy today to keep data on CDs. You can keep an entire project worth millions of dollars on one CD, and they're all your documents, and you take them with you. You may only work 6 months for somebody, but you keep 6 months worth of work. That's your insurance policy. Memorialize the individual meetings with the subs, especially regarding remove and repair orders. If you tell a sub to tear that work out and do it again, you take photos before and after to show that he in fact complied with the architect's plans when he did the repair. Excuse me. If you don't, the assumption is, and it's a rebuttable assumption, that you didn't do anything. That you, the superintendent, did nothing. Memorialize your change orders and your requests for instructions, and track back and forth all communications. As I said, get to know your architect. He has to become your best friend. Take him to dinner. You know, take him water skiing. Become his friend. You will need his or her guidance, and you need it in writing. They can be your lifesavers. because they will have to testify either for you or against you at trial. They will certainly be called. Now, if you think this is a lightweight proposition, I know that Brother Everts just testified back east, or was it Colorado? He went to-
They all came here.
Oh, they came here to depose him. So he has been run through the ringer, and he's going to have to go back east to Pennsylvania or New York or someplace and testify at trial because he wore a hard hat and he worked at a project. This is not a fun experience. You would much rather meet your lawyer out on the lake or going fishing or elk hunting even if you know some good spots. You would much rather do that than meet him in a courtroom preparing for trial. It ain't the way to go, folks. It ain't the way to go. I so admire you folks because at the end of your career, you're going to be able to say, I built that house, I built that building, this is my freeway overpass. You will have left your marks on the face of the land. As a lawyer, all I have is paper. And we all know what happens to paper. So I commend you folks for coming to school here. I'm excited for you. You have some great careers ahead of you. The world's a good place, and I know that you're going to make it even better. Thank you very much.
Okay, thank you, Mike and Sharon, for coming out here and taking your time. Really, what Mike had to share with us was absolutely phenomenal. And you will run into it in the industry. So just be prepared. Hopefully you took good notes, and we'll see you next week.
Got an announcement.
Okay.
The ASC competition, there's a meeting tonight at 5:30 for anybody that participated in that this year and anybody that's interested in participating in it next year in room 127.
Thank you.
Food will be provided